Mr. Liu, Justice Gorsuch raises an important point about the surplusage. On the other hand, I guess Congress often drafts things to be redundant and overlap, and ordinary people communicate that way, particularly when they're giving instructions too. So both, Congress would much rather have overlap than leave a hole.
Exactly. And I think there are two strong
But how do we know? But at the same time, we do have the surplusage canon. I mean, the Eskridge book says it's often unrealistic. The Scalia book says, sometimes drafters do repeat themselves and do include words that add nothing of substance. And I think that's right. But how do we tell?
Yeah, I think here there are three clues as to why Congress embraced a belt and suspenders approach. One is the historical, ordinary meaning understanding of these terms. If you look at the dictionaries and the dictionaries that existed in 1946, these are overlapping terms, and Congress included them in the statute anyway. The second point I'd point to is the way Congress approached the intentional tort exception, which is in 2680H. There, Congress used overlapping terms. It included both deceit and misrepresentation, even though, as this court pointed out in footnote 16 of Newstat, deceit encompassed all kinds of misrepresentation. That was the understanding of the restatement first of torts. And the last thing I'd point to is the importance that Congress attached to the postal exception. This was not an afterthought exception. This was an exception that was in the earliest drafts of the FTCA. It's the very second exception listed. And you can understand why in 1946, when writing a letter was the only way to communicate in writing, that Congress would have wanted to protect that postal function.
Counsel,